Welcome to Medmarc's webinar series. Today's presentation is titled Current Regulatory and Litigation Developments in the 510K Process, Everything You Need to Know and More. I'm Courtney Young, an attorney in Medmarc's Risk Management Department. On behalf of Medmarc and today's presenters, Beth Rose and Paul Farquharson, thank you for joining us. Ms. Rose is a member of Sills, Cummis, and Gross, where she chairs the Products Liability Practice Group and is a co-chair of the Litigation Practice Group. She's tried complex product liability cases to verdict in state and federal courts throughout the country. She has over 25 years of experience successfully defending complex product liability matters for a variety of regulated products, including pharmaceuticals, medical devices, consumer products, foods, chemicals, and construction and industrial machines. She also has experience defending product liability cases which arise from clinical trials and catastrophic workplace accidents. During her career, Ms. Rose has served as national counsel to several companies, including those in the pharmaceutical, medical device, and contract research organization spaces, defending mass tort litigation. Paul Farquharson is a principal at Semmes, Bowen & Semmes, and practices out of the firm's Baltimore and Washington offices. Paul leads the firm's Special Risk and Complex Litigation Group. He has successfully defended clients in high-exposure insurance coverage, toxic tort, and product liability disputes for over 30 years. During that time, he's served and continues to serve clients in various capacities, including as national and multi-district litigation counsel for product manufacturers and distributors in drug and medical device litigation. He's also been heavily involved in several large insurance coverage cases involving environmental cleanup costs, bodily injury, property damage, and products liability claims. He's an experienced trial lawyer and has tried cases in multiple jurisdictions and venues, including London-based arbitration proceedings. With that, I am pleased to turn things over to Beth, who will begin today's presentation.
Good afternoon, everyone, and thank you for joining us. As Courtney mentioned, Paul and I will be talking about current regulatory and litigation developments in the 510K process. First, I will talk about the significance of the evidentiary issue in the litigation context. Then we will take a step back and give you a little bit of a regulatory primer and talk about some of the key federal cases that are guiding the discussion. We will frame the issue in terms of trials so you can see how the issue plays out, and then address some of the evolving case law, kind of the good, the bad, and the ugly. And then Paul will talk about some important regulatory developments that are on the horizon, and with his crystal ball, he will make some predictions. So let's just dive in terms of the significance of the evidentiary issue. And if we were all together, I would ask you, when you see a slide that says 99% versus 1%, what does that kind of evoke in your mind? What it probably does not evoke in your mind are statistics from a 2009 Government Accountability Office report. In that particular report, the GAO looked at FDA reviews of medical devices for the period of 2003 to 2007. And what they reported was that during that time period, about 13,200 medical devices were evaluated through the 510K process, as opposed to 217 medical devices that were evaluated through a pre-market approval process. And if you do the math, what this means is that nearly 99% of medical devices that are evaluated by the FDA are cleared through the 510K process, as opposed to 1% of medical devices that go through the PMA process. The takeaway is that the 510K process is really the most commonly used pre-market pathway. These statistics really kind of bear out generally as you move forward in time. There are a set of statistics from 2017 that show that 82% of devices cleared by the FDA were cleared through the 510K process. So if our takeaway is that most of the medical devices that go through the 510K, that go through the FDA are cleared through the 510K process, what we also see is that most medical devices that are the subject of litigation are those that have gone through the 510K process as well. And in my career, I'd say that all but maybe a handful of medical device litigation that I've handled are Class 2 medical devices. If you juxtapose that with what's happening in the environment, you see how important this is. And what I have here is an excerpt from a New York Times article that appeared just a couple of months ago, May 2019. And if you just look at the title, it's a little bit foreboding. 80,000 deaths, 2 million injuries. It's time for a reckoning on medical devices. If you read the article, this was an unabashed critique of the 510K process. The 510K process was referred to by this author as a regulatory loophole as opposed to a requirement or a criteria or some important standard that manufacturers of medical devices must follow. And I bring this up because I think it's important that we recognize that it's these types of articles that are in the public consciousness. These articles are read by judges, throughout the country. It is in this context and this environment that federal and state court judges are considering whether or not they should either admit 510K evidence at trial or whether they should exclude it. So if we take a step back and just look a little bit about the regulatory history, you may or may not be aware that prior to 1976, and specifically to the medical device amendments of 1976, the prevailing statute, the Federal Food, Drug, and Cosmetic Act, it did not authorize FDA to regulate new medical devices. And so with with the medical device amendments of 1976, the FDA set out to begin more aggressive regulation of medical devices. And so what the FDA did was they classified medical devices into one of three classes: Class 1, Class 2, Class 3. Class 1 devices were low-risk devices, think, tongue depressors or latex gloves. And those types of medical devices would be subject to general controls. Class 2 medical devices, more moderate risk. And then Class 3 medical devices were higher risk devices. Those devices would be subject to a pre-market approval process where the medical device manufacturer would have to establish safety and efficacy. So for a Class 3 device, for example, think of an implantable device. But what was going to happen to devices that were still on the market, that were on the market in 1976 when this legislation went into effect? They could just, pull them off the market. I mean, that would have had, a horrible impact. So Congress decided that all medical devices that were currently on the market would be grandfathered, and they would be allowed to continue to be used. That raised another question about new devices. Would new devices that still had to go through a process, would it be difficult for manufacturers to introduce these new devices, and would the manufacturers of devices that had been grandfathered, would there be some type of, monopoly? And the way Congress addressed that particular issue was that it said, if there is a new device that can show that it is substantially equivalent to the device that is currently on the market, then the FDA will clear that device to be marketed in the United States. And the section of the statute is 510K. That's how the 510K process came to be. So under the 510K process, if the manufacturer can show that its device is substantially equivalent to the device that's on the market, which is now really called, we all call it a predicate device, then the FDA will clear that device for marketing. Well, what is substantial equivalence? Has been a lot of debate about this. A common refrain by plaintiffs in the litigation context is that the 510K process really doesn't amount to much of anything. It has nothing to do with safety and efficacy, and we'll talk a little bit about more about that later. But I think if you kind of flash forward from 1976 and look at some of the language from the Safe Medical Device Act of 1990, you'll see that safety and efficacy are important components of the 510K process. And you probably know that the Safe Medical Device Act of 1990 was designed in part to enhance and clarify FDA's oversight over medical devices. In this particular statute, substantial equivalence is defined, and I won't read the whole thing to you, but you see that I've underlined that part of the definition that talks about the process and talks about the importance of the manufacturer demonstrating that the new device is as safe and effective as the legally marketed device, and that the new device does not raise different questions of safety and efficacy than the predicate device. Now, to be sure, there is not an independent analysis of whether or not there is safety and efficacy in the same way that the PMA process requires. But safety and efficacy is part of the 510K process and is combined and considered in the context of the predicate device. And if you were to look at FDA guidance documents, at FDA information that is publicly available, you will see that the FDA considers safety and efficacy to be a part of the 510K process. What I have on the slide right now is just an excerpt from a regulatory, from an FDA guidance document from 2014, where the FDA describes its 510K process. And you can see that I've bolded references to a reasonable assurance of safety and efficacy, where FDA says this process requires FDA to determine issues of safety and effectiveness presented by the new device. Similarly, if you were to go to the FDA's website, right now, and you were to look at the description of the 510K process and substantial equivalence, you would see that the FDA's view is that substantial equivalence is established with respect to the predicate device based on a number of different factors, design, materials, performance, but safety and effectiveness are two of the criteria as well. So while it seems pretty easy to, just say, well, the 510K process involves safety and efficacy, or certainly looks at safety and efficacy, it's been a much harder argument to make in the courts. And I'd say that one of the reasons that it's been so difficult to convince judges that safety and efficacy is a part of the 510K process is because of two U.S. Supreme Court decisions related to medical devices and preemption. The first one is Medtronic versus Lohr, and the second one is Rico versus Medtronic. Now, interestingly, Medtronic versus Lohr was one of the, first preemption cases in front of the U.S. Supreme Court. And there the court was asked to consider whether a Class 2 medical device, a pacemaker actually, whether failure to warn claims related to that pacemaker were preempted by the medical device amendments of 1976. There is an express preemption provision in that particular statute. And within the context of that discussion, the Supreme Court looked very specifically at the PMA process and compared it to the 510K process. Ultimately, the court decided that there was no preemption. But for our purposes, there's some very unfortunate language in this case related to the 510K process and its value or lack thereof. I just pulled out a quote here so you could get the flavor. So the court wrote, substantial equivalence determinations provide little protection to the public. These determinations simply compare a post-1976 device to a pre-1976 device to ascertain whether the later device is no more dangerous and no less effective than the earlier device. If the earlier device poses a severe risk or is ineffective, then the later device may also be risky or ineffective. Ouch, that's not helpful at all. And then throughout the opinion, the court repeats over and over again that Class II medical devices have never been formally reviewed for safety and efficacy. Plaintiffs in product liability cases love to cite to law to make their point that the 510K process does not relate at all to safety and efficacy and that evidence of it should not be admitted at trial. That was in the 1990s. Again, kind of moving forward into 2008, the Rico versus Medtronic case, there the issue was whether or not a failure to warn claims against a Class III medical device were preempted, and the court found that they were. But as part of that decision, the Rico court went back and looked at what Lohr had discussed in terms of the 510K process and the PMA process, and really kind of reaffirmed what was in the Lohr decision. There had been some discussion as part of this case as to whether or not the 510K process imposes any type of requirement or criteria, and the Rico court found this is not the 510K process is not a standard, it's not a criteria, it's not a requirement. It looked at that process as a qualification for an exemption to a requirement. So any of the cases you're reading, you'll see Medtronic v. Lohr, Rico v. Medtronic are really front and center in the plaintiff's briefing. Now, there is some case law that is helpful to defendants on this point. The Buckman decision that we all like to cite about implied preemption has got some helpful language and recognize that both PMA and 510K processes are designed to ensure that medical devices are safe and effective. There's also the Oterror case out of the Central District of California from 2018 that rejects the interpretation of law that I've just been talking about. But on the whole, the Buckman case and the Oterror case are not holding as much weight from my perspective as Lohr and Riegel when it comes to judges taking a look at this particular issue. So that's the background or the kind of the setup for how these issues play out at trial. And in terms of framing the issue, I thought I'd talk about a couple of verdicts in my home state of New Jersey to try to bring home the point. There is a multi-county litigation in New Jersey involving pelvic mesh litigation. There have been a number of trials in Bergen County, which is the northern part of New Jersey, which is typically a fairly conservative jurisdiction. And what I have here are two cases that were tried, two pelvic mesh cases that were tried, one against Ethicon, one against C.R. Bard. The HiMock case against Ethicon was tried a couple of years ago. There was a $16 million verdict, $6 million compensatory, $10 million punitives. And then in April 2019, in the McGinnis case, a $68 million verdict, which is really huge for this part of the country and specifically that county, 35 compensatory, 33 million punitives. In both of those cases, evidence of the 510K process was excluded in both trials. And the way that kind of came up is in the in limine motion phase, where I call them dueling in limine motions. The plaintiffs are essentially moving to bar the defendants from discussing the FDA process, from discussing FDA's oversight of the devices. They don't want the manufacturers talking about FDA design or labeling requirements. Defendants are obviously, lobbying to the judge to allow that evidence to come in and for them to be able to discuss it with the jury. In the New Jersey cases, the trial judge excluded the evidence of the 510K process totally. And as a result, the plaintiff's lawyers were really able to exploit the ruling throughout the trial. What I've pulled out here is an excerpt from an opening statement of the McGinnis trial. And the way it was exploited was that the plaintiff's counsel over and over again told the jury Bard never conducted clinical trials. They never tested these products. They just tried to rush them out into the marketplace. And because of the in limine motion ruling, Bard wasn't able to say, wait, time out. The FDA has a process. It's the 510K process. Here's what we're required to submit. There is no requirement to conduct clinical trials on our own. But they're not able to do that. So the plaintiff's lawyer in the McGinnis case is able to get up in front of the jury and say, Bard didn't think it had to do a clinical study in actual patients. This is what they knew, and I'm going to say it again. They didn't think they needed to do a clinical study with this, meaning the pelvic mesh products, to see what happened in actual women. And so this is how the playing field is really, tilted towards the plaintiffs. And here are the, high-level arguments that the plaintiffs advance to try to keep this evidence out. There are two components to it. First, they argue that the evidence is not relevant. It's not relevant to their design and warnings claims because, and this will now be very familiar to you based on our earlier discussion, the 510K process doesn't address whether or not the device is safe and effective, and it doesn't impose any federal requirement in and of itself. Remember the Rico court talking about it as an exemption. The plaintiffs continue that if by some chance there is some small amount of relevance, that relevance is outweighed by the prejudice that the evidence would lead to. The potential for confusion outweighs any potential relevance that it has. And they've got some specific arguments that they've now started to make on a pretty consistent basis. They argue that, look, if you allow this 510K evidence to come in, there's going to be a mini trial on FDA enforcement, FDA regulation, the 510K process. This is going to lengthen the trial. The trial is just going to go on and on and on. And it's going to be a complete distraction because the jury is going to start to focus on whether or not the manufacturers complied with the regulations. Second, they say if evidence of 510K is admitted, then the jury is going to be completely misled to believe that the FDA is making a safety determination. And the jury is going to assume that because the FDA looked at the devices and allowed the devices to be cleared and marketing, that the FDA somehow made a finding of safety. They argue that experts are going to be offering legal conclusions. You'll basically have plaintiffs' experts on the one hand, defense will have FDA experts on the other, and it will just be a battle of the experts over these regulatory issues. In other words, judge, keep this out. This is more trouble than it's worth. Defendants have their own set of arguments, several of which I find extremely compelling. Defendants have argued, this regulatory history is, of course, relevant to reasonableness of our product design and product labeling. And often under state product liability statutes, one of the factors in, evaluating the device is whether or not the manufacturer complied with any particular standard. So defendants are saying, wait, time out. We are entitled to show that we followed the rules that the FDA outlined for us. Second argument is that it's important for manufacturers to be able to put their conduct into context before the jury. Most juries are going to know or assume that medical devices are regulated by the FDA, and they're going to expect to hear something about the FDA role with respect to the devices. If defendants are precluded from discussing the role of the FDA, the jurors may come away with a misimpression that the company went rogue and just unleashed products into the marketplace with no regulatory oversight. Flip side is that defendants are really prejudiced by being unable to respond to some of these really outrageous claims that plaintiffs make, in terms of, for example, a failure to conduct clinical trials. And finally, I think this evidentiary issue really has a very adverse impact on manufacturers who are subject to punitive damages claims in these cases. Certainly in New Jersey, an important factor in whether or not punitive damages are imposed relates to the conduct of the manufacturer. And by excluding evidence of the 510K process in the liability phase of the trial, that ruling often, or at least always in my experience, bleeds into the punitive damages phase, and the manufacturer is not able to explain its interactions with FDA, the role of the FDA in clearing the process. And so, ironically, in terms of the punitive damages phase, the focus of the jury's consideration is the conduct of the manufacturer. Yet, as a result of this ruling excluding 510K evidence, the manufacturer is not able to explain its own conduct. So how has this issue kind of played out in front of the courts? Unfortunately, I don't have great news for you, at least as of this point in time. The weight of the authority in both state and federal courts really favors exclusion of the evidence for the reasons that plaintiffs advance and the arguments that they make. I cited there are many cases excluding the evidence. I chose these 4 cases because they're all federal court cases. They are all from appellate circuits. 3 of them are from the 4th Circuit. 1 of them is from the 11th Circuit. The pelvic mesh litigation, there was an MDL and still is an MDL, several of them actually, in West Virginia. The MDL judge is Judge Goodwin. And so I don't want to say I blame him. Maybe I hold him responsible for many of these adverse rulings. In the Sisson case, that was one of the first cases to be tried. He excluded evidence of the 510K process in the in limine motion stage. When Bard lost that case, there was a motion for a new trial. One of the bases for the motion was the exclusion of the 510K evidence. He denied the motion for a new trial. Then the case goes up to the 4th Circuit, and when the 4th Circuit looks at the issue, they're looking at it as an abuse of discretion. They affirmed Judge Goodwin's ruling and then have now affirmed it 3 other times. So it really has kind of spiraled on itself and become, a life of its own, with Judge Goodwin's rulings being adopted by federal courts around the country and also state courts around the country as well. There is a little bit of light at the end of the tunnel, I would say. There are kind of a handful of cases, and I've identified 3 of them here, where courts are starting to, realize, like, okay, well, we may not agree with the defendants that this evidence is as relevant as the defendant is arguing, but it does have some relevance, and it really is the only pre-market criteria for a Class 2 device. So it may be prejudicial to let it all in, but it's also really prejudicial to keep it out. And so in these 3 cases, the court has found that evidence of the 510K process can come in, but it comes in subject to a limiting instruction, so that the jury is told just because the FDA cleared this device and allowed it to be marketing isn't dispositive of the plaintiff's design claims or failure to warrant claims. So we'll have to see how these cases, morph and evolve in the future. But that's really the update on the litigation front. And I'll now turn it over to Paul, who will give you an update about some really important regulatory developments that have the potential to impact all of us. Paul?
Good afternoon, everybody. Thank you for your time this afternoon, and thank you, Beth, for an excellent presentation and primer on the 510K process. So what I'm going to talk about today is a change that rolled out at the beginning of the year, end of January, early February, but which was over a year in the making. And that's the safety and performance-based pathway. And the safety and performance-based pathway is part of the FDA's Medical Device Safety Action Plan. And that was rolled out, like I said, about a year or so ago. And it includes this pathway. It also includes a second portion that the FDA is still considering whether or not they're going to enact, and they're taking public comments on it. And the second piece is the identification of current devices which used older predicate devices for their 510K approval. Now, hearkening back to a little bit of what Beth was talking about, when the Medtronic cases were decided, particularly Medtronic versus Lore, the 510K process was really a fairly new process. Maybe it had been in place for about 20 years. Since then, certain PMA products that have been approved through the PMA process have been downgraded, or shouldn't say downgraded, but have been reclassified into Class 2 products. So what you can do now with the 510K process is look to a PMA product, essentially, as a predicate device. It will be interesting to see what happens if and when such a device is brought up on product liability claims, and if we get to the introduction of the 510K process, because for such a device, the 510K process would be able to point to a predicate device that had gone through rigorous clinical study evaluation. So that's something to keep in mind as we move through this new regulatory environment that's being established. So let me tell you a little bit about the safety and performance-based pathway. It's got a great name. It's got a much better name than the old 510K process, which is just substantial equivalence. Now, the test for substantial equivalence under the new safety and performance-based pathway is still comparing it to a product that pre-existed. But instead, the FDA is going to provide, they haven't promulgated them now, but they are going to promulgate specific tests that need to be performed on the new product to show that it is substantially equivalent to the predicate product. So we've got a similar evaluation going on, but it's not simply comparing product to product. There will be independent criteria that will be evaluated. Now, why is that important? It's important in the context of what's out there in our community, what are our fellow citizens seeing, in particular, what are plaintiffs seeing, and even more importantly, what are potential jurors seeing. Beth talked a little bit about it on with the New York Times article. That's something that maybe not too many of your jury pool will have read, but certainly, as she pointed out, judges will be more likely to have read the New York Times article. And the New York Times has with it a very serious reputation for being a serious paper, even though I am not altogether certain that the May editorial was all that well researched or should be taken as seriously as I think people who are not familiar with these processes will take it. But more importantly for your jury pool is a Netflix program called The Bleeding Edge. And if you're in this industry, whether you're on the side of dealing with problems with products after they are marketed, or if you're in the side of the business where you're bringing products to market, If you haven't seen this Netflix program, you must watch it. It's about an hour and 40 minutes long, and it is an hour and 40-minute long plaintiff's opening/closing argument. You will be terribly concerned if you watch this program, and therefore you should watch it. Rotten Tomatoes gives it a 100% on the tomato meter, and it has an audience score of 83%. So what is this program about if you haven't seen it? Well, it's a program about a number of different products, the DePuy hip implants, the Da Vinci robotic surgical assistant, eSure vaginal mesh, and it really takes a frontal assault on the industry and the FDA. It also includes with it an interview of the author of a book called The Danger Within, which also takes a full-on assault or makes a full-on assault on the device industry. Now, some specific quotes from the Bleeding Edge that I'd like to bring to your attention. They tell us that the industry has captured the FDA, and they say that it's captured the FDA more than Big Pharma. So if you pop down, you'll see where it says device industry is much more powerful than Big Pharma. Keep in mind now the publicity associated with the opioid litigation that has pretty much gone nationwide, where not only do you have class actions and individual claims, but you've got attorney generals from states bringing cases, and you've got municipalities, cities, counties bringing cases against opioid manufacturers. One of the heavy hitters that the Bleeding Edge includes is Dr. David Kessler. He was the chairman of the FDA from 1990 to 1997. He is highly regarded. He is a pediatrician. He also has a law degree. He took his medical degree from Harvard, and he took his law degree from the University of Chicago. He likes to point out that Bush appointed him and Clinton asked him to stay on. He now serves as an expert witness for plaintiffs. I've had the privilege of taking his deposition, and he makes an excellent witness. Dr. Kessler will reinforce the notion that the 510K process is in fact an exception, that it's a loophole to the PMA process, and he will tell you that regrettably it is now the rule rather than the exception. There's a quote from him, and he says, "The problem with devices is we built a system that doesn't work." That's powerful stuff coming from a former chairman of the FDA. The program has other quotes in there. I've listed some of the more inflammatory ones. We are told that kickbacks are legal. We learn from one of the people they interview that there's dark money and secret funding out there. And again, we're told that the industry is much more powerful than Big Pharma, and that that's us, the industry, they're paying for the research so they get the results they need. This is the environment that we're working in. So if you're a lawyer on the program here today, you need to watch that, and you need to be careful if you can in your voir dire to ask potential jurors about whether they've seen this program, what they've taken away from it. Have they read the book that's referenced there? If you're part of industry on the other side, you're not litigating these cases, you need to know that as you go through the approval process, this is how the public is viewing or may be viewing the products that we continue to roll out. So as I mentioned earlier, the final guidance for the safety and performance-based pathway was issued earlier in the year, and we may get a list of older predicated devices. The FDA is still working on that. So what does this new pathway apply to? Well, it applies to what the FDA is calling well-understood devices. They intend to publish a list of well-understood devices so that you can use this pathway if you can find a predicate device that is encompassed on this list. The FDA suggests that this will be an expansion of the abbreviated 510K program, which Beth talked about at some length earlier. So the FDA is looking at this as an improvement to the 510K process, and that it will apply only to those devices for which we have a good and firm understanding of them. The safety and performance-based pathway is an attempt to strengthen and modernize the process. This is what the FDA is rolling out. The FDA is suggesting that this process will be both less burdensome but still robust. We need to question whether or not this is possible, and if it's possible, what is it going to look like? And the reason we need to do this is because, as I mentioned briefly introducing this, the comparison now is not simply, does my device act and behave like the predicate device? They're going to have additional criteria. I believe that those additional criteria will certainly make the process more robust. I'm not sure, though, that it will make it less burdensome. We'll have to see how this plays out and precisely what criteria the FDA is going to require the manufacturers to provide when presenting the new device under this pathway. The FDA is suggesting that it will be a more efficient review, that it may be faster and it may be less expensive. Going back to what Beth was talking about from the litigation perspective, what impact will that have on new challenges to the admissibility of approval under the safety and performance-based pathway? Can we have a pathway that is faster, less expensive, more efficient, and yet still more robust, and possibly more robust in such a way that it will increase the chances of having that approval process introduced into evidence in the event your product ends up in litigation? So let's talk through this new pathway as best we can, given what we have been provided by the FDA. So substantial equivalence remains the basis for approval, and you still need to have a predicate device. What's changed is, instead of simply comparing the two devices, we're going to be given a list of objective safety and performance criteria. The FDA is telling us that these criteria will reflect current technological principles and practices, and that there will be no need to review the data from direct comparative testing. So trying to test the predicate device against your device, that process will no longer be necessary. Companies may still want to try and do it to provide additional information and data to the FDA, but it won't necessarily be a requisite. The idea here is that we will be developing this independent data, not just from comparisons, but from other testing protocols. We will be developing independent data to demonstrate a level of safety and performance consistent with the predicate device. So while we still look back to the predicate device, I expect that we'll be able to point to data, not clinical trials, of course, but other data, other testing that will help, I think, both defend the product against accusations and may also increase the likelihood of admissibility of that process. Now, the FDA is going to limit the use of this pathway, certainly at the beginning. They will be providing future guidance. And what is that future guidance going to look like? They are going to detail the types of devices that they consider to be the well-understood devices. We don't know quite yet what those devices are going to look like, so we're waiting on the FDA to provide us with this list or a list of categories for devices that can take advantage of this pathway. They will also be publishing applicable performance criteria, and those criteria will be detailed, and they will have the characteristics that we discussed before, be current technological procedures, protocols, and information. The FDA will take on the burden of maintaining and publishing all of the devices that are the types of devices that will be appropriate for this new pathway. Ultimately, the FDA is telling us that they intend to make this new safety and performance-based pathway the primary pathway, the primary framework for the 510K process. And I think the reason they're doing this is they are trying to get away from this notion that a predicate device that existed prior to 1976 has never been tested, that predicate device somehow, as the Supreme Court has suggested in its opinions, that device somehow hasn't been subjected to any kind of rigorous testing or evaluation. And to remove this notion that the 510K process is really an exception to the approval process. So let's move on now to the older predicate device portion of this rollout. The tension with trying to identify older predicate devices as opposed to younger predicate devices is part of the basis for the 1976 era grandfathering is that we had a history of devices that had success and had safety. So you don't want to criticize or subject devices that have been approved based on these older predicate devices by somehow implying or impugning the fact that they are predicated upon these older tried and true devices. There's a very good reason why the 510K process was put in place. On the other hand, we have a community now where people are replacing their phones every 2 years. Your computer is essentially out of date 6 months after you buy it. People understand this. Some people have come to internalize it. And so when you have these people on a jury and they're looking at the safety and efficacy of a medical device that was predicated upon a device that was greater than 10 years old, there's some tension there as to whether or not the argument that this is tried and true and doesn't need to be changed or updated versus the impression that anything that's old is somehow not as good as that which is better. So we're waiting to see if the FDA rolls that out, but that is essentially the tension there that the FDA is dealing with. My research right now, the reaction among industry representatives appears to be that they would prefer the FDA not provide a list of predicate devices that are predicated, or a list of devices that are predicated on 10-year or older devices. The concern is that this will become some sort of blacklist or hit list, that if your device happens to be on that list, or if your predicate device is on that list, that somehow your device is going to be subject to greater scrutiny. So what's the FDA's, final involvement in this, and where are we headed? We've talked about the identification of the devices by the FDA. We've talked about FDA providing the tests to use to secure the data under the safety and performance-based pathway. We know that the FDA, at least now, and I think continuing, will suggest that this will provide increased safety for the devices that are approved under this new pathway. The FDA is also hoping that this will be an efficient way to get new products to market with an increased safety factor. From the litigation perspective, Where does this lead us with preemption? We know that Class 2 devices under the current jurisprudence do not enjoy preemption. However, if an argument can be made that there is additional testing, there is additional criteria that are being applied and evaluated during this process, can we attempt to take advantage of the preemption protections provided by the Act with respect to the Class 3, the PMA-approved devices? I think we need to keep an eye on that, and it might not be a bad run to make in the right case with the right device. So the litigators out there who are looking at this is something to keep an eye on as you move through your practice. So predictions. So here's where we get to what I think we're going to see with this pathway. I do think it will increase chances of admissibility as long as the criteria that the FDA provide us generates some sort of new data, some sort of new information about the newly approved product that isn't simply it walks and it talks like the predicate device. So we'll need to wait and see what those criteria are and what kind of data those criteria provide to us. The other option is that it decreases the chances of admissibility for this approval process. I don't think that's going to be the case unless what happens is we see a speeding up of the process without the rigor and the robust nature that the FDA is suggesting will accompany the new process. So I think, Beth will be happy and I will be happy that these new approval process will enhance the chances of admissibility. I think it may give us a new run at preemption. What is the burden on industry? Will older but safer devices be abandoned? We don't really quite know that, but we do need to be careful in thinking about this new process. What is it going to do with our older, tried and true devices if we find that the FDA really is pushing for a new safety and performance-based approval for older devices? And that will be prompted, I don't think necessarily by a regulation issued by FDA, but if FDA does publish this 10-year-old plus list, will industry look at that list and say, we really need to get our devices off that list? It also gives us the option to consider, will there be an increased need for more products going through the PMA process? If all of your predicates will ultimately, sort of in a daisy chain way, relate back to pre-1976 devices, or if most of them will manufacturers decide that they need to try pushing more products through approval under PMA? Now, one thing to keep in mind, I had a client tell me that they had a product they were trying to have approved via the PMA process, and FDA said, no, this needs to be done under the 510K process, which is interesting because the PMA approvals are a significant burden on the FDA. So if they're looking at a device that can be approved under the 510K process, they may end up sort of shepherding or funneling those products into the 510K process. Will this increase the cost to consumers? I think that's a very good possibility if, in fact, the safety and performance-based pathway ends up being more costly to apply. So we're just about at the end of our hour, which is good because I'm just about finished. And Courtney, I think we're ready for questions.
Okay, great. Yeah, we had a couple that have come in already. So for either of you, is it true that a device can be approved under 510K if the predicate device was never approved by the FDA?
I can take a gander at that one. Yes, that is true. I mean, many of the predicate devices have never gone through any type of formal approval process. So that is correct.
Okay, thanks. How about for if the predicate device has been recalled, can a approved device still use that predicate device?
Yes, in our experience, even when a medical device is recalled, it can still, in certain circumstances, serve as the predicate device. These are some of the potential vulnerabilities I think that the 510K process has when it comes to defendants making arguments as to why the evidence should be admitted at trial.
Okay.
Yeah, let me jump in there, Courtney, for just a minute. I've not seen, and that doesn't mean it can't happen, but I've not seen a device use a predicate device that has been recalled when it seeks 510K approval. Where I've seen this happen, and Beth may have a different experience than I, but where I've seen this happen is you've got a predicate device that has been recalled for some reason. And it may be recalled because there was a manufacturing problem with a particular batch of devices, whatever it may be. You've got that predicate device recalled. Devices that have already been approved based on that recalled predicate device remain on the market, and there's nothing wrong with that. So it's interesting because the plaintiffs will make that argument or will make that challenge to a device and saying, these devices can be based on recalled devices, but we need to be particularly aware of the specifics associated with those recalls.
Okay, thanks. And it looks like we can probably squeeze in one more question here. For either of you, what impact will the cessation of the summary reporting process have on ongoing litigation?
Beth, if you don't mind, I'll field that one.
Sure.
The FDA is in the process of making MAUD, which is the adverse event reporting system, available to the public, making it more available to the public and in a more user-friendly fashion. As part of that, they're trying to eliminate some of these summary exceptions where instead of reporting individual adverse events, people can or companies can report summaries of adverse events. Those exceptions are being eliminated, and possibly a new exception protocol may be instituted. But what this will how this will affect litigation is twofold, depending on your particular device. If your device has few, if any, adverse event reports, you can point to this database and suggest that this device has a good and safe history. If your device has multiple adverse event reports, and if those adverse event reports cannot be summarized but must be reported individually, then you're going to have a more difficult problem with this data if the plaintiffs get a hold of it and if they attempt to use it. So I think it can cut both ways depending on the experience of your product in the market.
Okay, thanks so much. It looks like we're right at the hour there, so I'll go ahead and wrap it up now. Thank you both so much for a great presentation. We'll have to stay tuned to see what happens with this process and if your predictions come to fruition. So thanks. Thank you for joining us. This concludes today's webinar.